you mean December 20, saying that yes, this is the amount payable for me in December of 2023. Lordship, against which I mean a writ petition before your Lordship.
Your liability is not fastened when the demand is raised. Your liability arises when you dispatch or consume the ore. You're not able to tell us when you consumed, and you would have said, no, I actually transported it on this date. Then we would have understood. There's no such.
Lordship, demand notice also doesn't say.
At best case, it will go back to the end of the year in which you raise your.
Lordship, my only last request, Lordship, is that even the demand notice doesn't mention that if you do not pay.
There has been no parliamentary legislation on a health university till this day. So therefore, the field relating to control and management of all health and allied sciences is exclusively within the state legislation, that is Rajiv Gandhi University. Now the regulations which have been framed under the UGC Act, according to us, are subordinate in nature, number one. Number two, Lords.
No, they've got a judgment. It's a binding precedent to us.
No, the judge, I'll answer that. The judgment which has been relied upon says that once regulations are framed under the UGC Act, they become part of the statute. That is the. But the Lordships have to see Section 26, which gives the power to frame those regulations. It does not provide for regulations of such a nature. This is going beyond Section 26. That is
you're not challenging the regulations.
We are not. We
otherwise challenge the UGC.
No, but I'll put it. I am bound to answer that question. I'm a university working under a particular statute. Today, that is being sought to be enforced against me. That is a question which is before your Lordship.
No, so when a regulations is enforced, and you argue on interpretation, it's all right. But you can't today challenge the validity of the.
No, I'm not. No, I'm
late to correction. We are not.
No, I'm not saying. No, sir. May I put it across? Now that question has arisen before your Lordships as to some sort of a conflict between the regulations and the statute, the court is bound to examine as to how should they be reconciled.
We can't reconcile it by saying that is invalid.
No, I'm not saying. I'm not saying invalid. I would say, this being a parent statute and that being subordinate legislation, but this would prevail over that. Number one. Number two, if Lordships have to see Section 26, I'm an university. I cannot challenge. I'm not a citizen in that sense. I cannot challenge the regulations of a central enactment. All that I'm saying that is sought to be enforced against me in a writ petition. But all that I can place before your Lordships is saying that look at this. These regulations are beyond the legislative or mandate of Section 26 itself. May I request Lordships to kindly see Section 26? On the face of it, these regulations cannot be. But at best, they are something which has been created by the officers of the UGC. Kindly see Section 26.
But you read 26.
I'm sorry.
You read this.
Please. Therefore, in the absence of there being any power at all to frame such kind of regulations, enforcement of that, when against the university does not arise. And lastly, if Lordships are to see the object of the UGC Act, the object, it is in fact an umbrella legislation meant with two primary purposes. Number one, to allocate and grant funds to the universities. Number two, to prescribe standards of education to the universities. The relationship of a university grants commission with individual institution being under another university does not arise at all. There is no provision.
No, they are not under any other university.
They are under our university.
They are under your university. There will be your overall control of the university will remain. Their functioning will be autonomous.
But Lordships, that is the reason I have given a comparative table. There for all purposes they go out. Only role we have is not to confer them a degree in some sort of a convocation. Except for that, there is nothing remains with us. Conduct of examination, control over the management, fee fixation, everything is under those regulations. The only thing which remains with us is to confer degrees. I'm not kindly look at the consequences. But not only this, they conduct examination, they prescribe standards, and finally, that the responsibility of conferment of degrees is upon us. That also they have done very consciously because Section 14 of the UGC Act says we cannot confer degrees. But this would kindly visualize the situation. Kindly look at this one. If medical universities, medical institutions, if all of them, if such regulations are made, and if they go and themselves can get an autonomous, we'll lose complete control. But this, in fact, Rajiv Gandhi University Health Sciences Act, it has a hierarchy of control: Senate, syndicate, vice chancellor, and then Academy of Higher Education. The reason, and they're all experts. It's a comprehensive legislation, but meant exclusive to control these institutions.
Not only two
And the Jagdish Prasad's judgment, which I have quoted, in one paragraph, in that written submission, if lordships are to see, the last paragraph, that according to me sums up the entire case, entire position of this one at para 37 in the written submission para 13. I'll just read this paragraph notes and I'll leave it to lordships.
Yes.
The authority of the Commission to frame regulations with regard to service conditions of teachers in the centrally funded educational institution is equally well established. As has been rightly done in the instant case, the acceptance of the scheme in its composite form has been left to the discretion of the state government. The concern of the state government and their authorities that the UGC has no authority to impose any conditions with regard to its educational institution is clearly unfounded. Kindly see the next statement. There is no doubt that the regulations framed by the UGC relate to Schedule 7, List 1, Entry 66 to the Constitution. But it does not empower the Commission to alter any of the terms and conditions of the enactments by the states under Article 309 of the Constitution. Under List 3, Entry 25, the state is entitled to act its own laws with regard to the service conditions of the teachers and other staff of the universities and colleges within the same, and the same will have effect unless they are repugnant to any central legislation. Under Entry 25. And this argument that they become part of the parent statute is too general or generic in nature. But every rules regulation obviously become part of it. But the fact of the matter,
see, it's not that. Where is the power of a delegated legislation? How do you trace it to the legislative competence? You trace it to the list. You trace it to Article 246, and then you trace it to the list. The distinction between whether it's a delegated legislation and a legislation is obliterated. It is a legislation exercise of that path.
True.
Your list 1 and list 2, which gets primacy,
yes.
And the concurrent list doesn't arise from whether it's a delegated legislation or whether it is. It's only an entry of the subject matter.
True.
The competence is traced back to 246. It's not a silo.
I understand, but
H.S. Dillon, it all said was, then don't look at the list.
Ultimately, you trace back to the
power is 246. Where is this power coming from?
I was
46.
No, I understand, but I was only trying to make this point that well-settled position that if there is a conflict between there is no provision of a primary legislation and the provision of a delegated legislation.
But that is the parent legislation.
That's true. That's what I was only. No, I understand. Under the same legislation, under the same legislation, but not the point. Not for lordship's kind consideration would still fall is that this is a comprehensive legislation under Entry 25, and that is under Entry 66.
Entry 25 is subject to 63, 62
Correct.
to 66 of Entry 1.
Correct.
I mean, List 1. List 1 provides for UGC. And then second is 26, Section 26 to be broadly interpreted was, I've kept that judgment, 2009 4 SCC. Second, as far as examination, other things are concerned, Pharmacy Council 2021, Supreme Court has specifically held, Rajiv Gandhi has no power, it's the Pharmacy Council decide. Teachers, standards, teachers, everything. I've kept that also 2021 judgment. But this is all more than that. I don't want to say. Grateful to you. And that Jagdish Prasad has no applicability. It's only with regard to teachers' conditions, service conditions. That's all. Great.
Go for UGC.
My learned friend wants to file one written argument.
Written arguments. UGC was present in the morning.
Yes, but
Huh?
like that, council wanted to make some submissions.
No, they were going to accept our contentions itself. Adopt our
They'll have to come and tell us if they're accepting your contentions.
It's not your contentions.
My apologies, my lord.
You just inform the council.
Nodi, leave that, Nodi. Just tell them.
The arguments of the Learned Counsel for the appellant and Learned Counsel for respondents. You have for respondents one. You have for respondent one.
Respondent. Indeed. Respond number one.
One.
Completed the arguments. List for considering the final arguments of on behalf of UGC. Just inform them.
I'll inform.
Put it on Monday.
Yes.
17th August. My lords, on written arguments which we've already submitted.
Only one. ACC.
Still number 22.
We have filed one application, my lord. Your lordships have modified the order in respect of everybody. BBMP, my lord, we have not been able to, my lord, get the final list. Everybody else has got. My lord, we have filed one application, my lord, on the same lines that your lordships had earlier, my lord, modified by your lordships order dated, my lord, 27/11/2025. We are all, my lord, for recruitment in respect of BBMP. Assistant Engineer BBMP. UGC ಅಲ್ಲಿ ಇಲ್ಲ ಮಂಡೇ ಹಾಕಿದ್ದಾರೆ ಬೇರೆ ಮಾಡಿ ಮಂಡೇ ಹೇಳಿ don't say you're adopting our argument. Simply say what you want to say. Right? ಹೇಳಿ.
Mr. Verma was to finish today.
Notice ready.
ಹೌದಾ? Only thing is, my lord, we have filed one application, my lord. Your lordships have modified, my lord, everybody else.
You know, we're on the final year.
All the, my lord,
Maximum
because in spite of it, your lordships modified the others.
4 or 5 weeks will
Very
have the order if they finish.
Very well, very well. I mean, I leave it to your lordship.
Hey, please. I'm sorry, I was not here.
No, no.
Yesterday, I was drawing the attention of the court to the extraordinary case that has been made out. Should there be a rule of 50%, then that is not an inflexible rule. And 5 reasons, I would call them Panchashila, 5 reasons given to make out the extraordinary case or the special case. 2 reasons I have already given. I will not repeat. One relates to the explosion of the SC/ST population over this period after 18% was fixed as the quota for them. Number 2, the growth of the number of KAS included in the list by the parliament under Article 341 from 6 to 101 and the scheduled tribes from 6 to 50 under Article 342. Having said this, may I request the court to kindly permit me to state the third important factor. Just the same way I mentioned about the increase of the population of the scheduled castes and scheduled tribes and the increase of their number, kindly permit me to OBC, they do OBC. In respect to the backward classes, sir, after the judgment in Balaji's case, the social and educational backward classes were wiped off the list of beneficiaries under 15.4 and 16.4 from 1962.
Yes.
Then Devraj Aras came to power in 1972 and constituted a new commission known as LG Havnur Commission. And LG Havnur Commission recommended reservation percent in the backward classes, socially and educationally backward classes, constituting, kindly permit to take the court to the second page of the opening page may kindly be seen.
Yes.
Percentage of recommended and reserved quota in Karnataka for socially and educationally backward classes, it may be. So 44.52% of the population was recommended for 32% reservation. Kindly mark it, 32% was recommended. But while issuing the government order, the government added the Muslims also into the same category and same percentage, namely 32% was given. In other words, from 44.52, the reservation was made at 11.67. I have produced the order dated 22 to 1977. Thereafter, a very interesting this thing was, a commission was constituted under one Mr. Venkat Swamy, and that commission report was not accepted by the new government, first non-Congress government which came to power. Page 21 is the order issued thereafter, typed copy. Yeah, it starts at page 5, typed copy from page 21. Kindly come to page 22.
Yes.
The government order dated 13/10/86. I request the court to kindly mark this very important development in the milestone of this thing.
Yes.
13/10/86, what did the government do? 32% remained the same. Venkateswamy Commission, which was constituted to revise that list, was rejected. The first paragraph, page 22. Although the state government constituted the Karnataka Second Backward Classes Commission with a view to ascertaining the classes of persons who have to be classified as backward class and second commission has presented its report. In the opinion of the government, the said report of the commission is not acceptable. I'll not trouble the court with the reasons why it is not acceptable. But kindly come to the last but one paragraph before the operative portion of the order. This is crucial. So I have already shown. So 44.52 plus 11.67 Muslims were added, constituting a percentage of 56.19%. Now what happened next is important. The state government has also taken into consideration the grievances of various sections of the society. At page 22, madam. The government order dated 13/10/86. I'm reading this. Yes. Before the operative portion, kindly come to the last but one paragraph. The state government has also taken into consideration the grievances of various sections of society, particularly those of the members of the 15 communities, including, kindly mark it, this is a very critical this thing, including Lingayat, Maratha, Kshatriya, etc. And bearing in mind the observations of the Supreme Court, etc., etc. Now, these 15 communities were newly added to the list without recommendation by any commission. Nobody found them to be backward, but this was held to be for a period of 3 years as a temporary measure. When Justice O. Chinnappa Reddy Commission was constituted, which presented the report in 1980. But these 15 communities were also declared to be forward by Chinnappa Reddy Commission. Nevertheless, they continue in the list of backward classes. So these 15 communities consisted of most populous communities like Lingayats, who constituted over 15% of the state's population, and Maratha, 3% of the population. Together, they constituted over 20% of the population.
Yes.
That brought the population of backward classes to around 70%.
Yes.
So I have shown the SC/ST population has reached 25.5, and the OBC population is nearly 70% of the population. Together, 90% and above, nearly 95% of the population is now asked to share only 50%, being 18% for SC/STs, 32 for backward class.
No, they are not excluded from the rest either. No.
Sorry?
This is reservation. This is not exclusion in.
No. I'm saying
in silo that 70%
No.
will get, 20% will remain unemployed and.
No. I am only showing the development of the yeah. How what was 32% for 44.52 became 32 for nearly 70% of the population. Likewise, what was 15 and 3 for scheduled tribes also, even after the explosion of the population as well as the number of castes. These are the three very important aspects I request the court to kindly consider as extraordinary circumstances which has warranted the enhancement of this. So these three factors having been said, the fourth very important factor is, kindly permit me to show the government order as it stands today, which is placed at page 41. If I may say so with respect, I also had the good fortune of presiding over the Backward Classes Commission. And I of course, I have not added any community. I retained the same, this thing, but rearranged the castes more equitably. 41 is the copy of the government order. Now, this is a government order of the list of socially and educationally backward classes. This is the order which is in operation since 2002. It has done. You have produced it also. Even the petitioners have placed it before the court. For ready reference, I have placed it. This list consists of 5 categories of backward classes. Category 1, backward tribes. Category 2A, backward castes. Category 2B, Muslims. Category 3A, backward communities. And category 3B, Lingaites and others. Now kindly come to page 50 of this order. The order commences at page 41. Kindly come to page 50. In category 2A, serial number 9 has included Buddhists who are religious minorities. Then kindly come to page 54. Category 2B, the entire Muslim community is included in the list as category 2B. Then at category 3B at page 55, kindly mark serial number 3 and 5, namely Christians are included, the entire community of Christians is included. And 5, Digambar Jains are included. In Karnataka, Jains consists of 2 categories, Digambaras and Shwetambaras. Shwetambaras are the Baniya community from north, a tiny section. Digambaras are in majority, Kannada speaking Jains. They have been included. In other words, entire religious minority communities find a place in the backward classes list. Muslims are there, Christians are there, Jains are there, Buddhists are there. Nearly 17% of the, according to the data made available recently, 17% of the population is covered by these communities.
That's what you said, 95% is covered, 95.5% is covered.
Yeah, no. In that 95, this 17% is also included, is my submission. Why I'm saying this is, I read out the speech of Dr. Baba Sahib Ambedkar. And I want this honorable court to give me the same benefit which was used, the same speech on the floor of the Constituent Assembly has been used to cut the reservation for 50. Yeah. The next sentence says minorities shall be considered under Article 296. So that is what is required to be done. Please, if you exclude these communities or the reservation that they have taken, I have not exceeded the limit at all. And this is the extraordinary case so far as Karnataka is concerned, by virtue of the inclusion of the minorities. kindly eschew from consideration from applying the 50% rule without considering this aspect. If this is considered, we are not in excess. Treating the Muslims, Buddhists, Jains, Christians as a separate category over and above 50. There is no breach of 50%. This the extraordinary case that has been made out is my very respectful submission. One very important factor to be brought to the notice of the court is that in all spheres, social, political, economic, the scheduled castes and scheduled tribes have been given proportionate representation. In political space, be it in the Gram Panchayats, urban local bodies, Lok Sabha, Vidhan Sabha, they have been given proportionate representation by virtue of the constitutional provisions. Likewise, Karnataka has enacted an act to ensure that the SC/STs get their due share in the budgetary allocations. So 2013 Act, it is called the Karnataka Scheduled Caste Subplan and Tribal Subplan Planning, Allocation and Utilization of Financial Resources Act 2013. Yes. The Act finds a place at page 68.
Yes.
So I'll not trouble the court with the other provisions. Kindly come to straight away section 7 onwards at page 73.
Yes.
Allocation of scheduled castes subplan fund and tribal subplan fund for financing the scheduled caste subplan, tribal subplan schemes included in this subplan. The nodal agency, while indicating allocation of the scheduled caste subplan or tribal subplan fund to the scheduled caste subplan or tribal subplan schemes, shall follow the following norms, namely, for schemes exclusively benefiting the scheduled castes or the scheduled tribes, individuals, or the scheduled castes or scheduled tribe households, 100% of the scheme cost shall be allocated and accounted for under the scheduled caste and scheduled tribe plan fund. For schemes benefiting the scheduled caste and scheduled tribe habitations, 100% of the scheme cost shall be allocated and accounted for under the scheduled caste or the scheduled tribal subplan fund. In case of other habitations, the cost shall be allocated and accounted for under the scheduled caste subplan or the tribal subplan in proportion of the population of the scheduled caste and scheduled tribes. Same provision follows in respect of all others. So, while making budgetary allocations, now this is the statutory mandate that the budget should allocate proportionally. Why I'm saying this is, in every area, the scheduled castes and scheduled tribes have been given cake proportionate to.
No, but in a sub-plan, when you make it for scheduled caste, the other budgetary allocation gets excluded.
My very respectful submission is, this is in respect of the budgetary allocation.
Therefore, there is a plan, there is a scheme, wherein certain enactments, when it comes to people's representation, when it comes to, you make a proportionate representation.
Yes.
And there is a conscious departure of not having a proportionate one here. What you are advocating is because you have there, you must have it here as well.
No, I'm not saying that. I'm not, for a moment, I'm not. All that I'm saying is Karnataka.
Some cases, of course, there is no, they started by saying when it comes to representation, there is, the scheme provides for proportion.
Yes.
But it also provides for exclusion.
What I respectfully submit is the Karnataka state has been following proportionate representation as a value, as a constitutional principle in all walks of life, including politics and economics.
No.
And it is keeping that in mind while assessing the march of the scheduled castes and scheduled tribes 70 years after the constitution came into force. They have been given only 15 and 3% as against a population of 25.5%.
Yes.
Now, this is one issue which has been the source of agitation among the scheduled castes and scheduled tribes who have been representing for the last 20 years, demanding enhanced reservation proportionate to their population. That is the demand. It is in that backdrop Justice Nagmohan Das Commission was constituted. I passed on the report. Before I take the court to the nitty-gritties of the report, I want to make this statement. Kindly permit me to show from the prayers made in these petitions. All the writ petitions, prayer is the same by and large. Namely, strike down the act. The prayer is to declare Act number 1 of 2023 and the scheduled castes and scheduled tribes reservation of seats in educational institutions and appointments or posts in services under the State Act 2022 is ultra-vires and unconstitutional insofar as it relates to increase in reservation from 15 to 17% to the scheduled castes and scheduled tribes in appointments and services. Now the Act consists of several provisions. In particular, Section 3 and 4 may I draw the attention of the court to the specific provisions under the Act. Actually,
Yes.
Act copy, court of 22A.
Yes. Yes.
Kindly come to Section 3. Reservation of seats. Having regard to the social and educational backwardness of the persons belonging to scheduled castes and scheduled tribes, The reservation in respect of each branch or faculty for admission into educational institutions in the state for persons belonging to scheduled castes and the scheduled tribes shall be 17% and 7% respectively. So this is the provision under Article 15(4). Class 4, Section 4. Reservation in appointments or posts in the services under the state. Having regard to this social and educational backwardness of the persons belonging to scheduled castes and scheduled tribes, the reservation for appointments or posts in the services under the state for the persons belonging to the scheduled castes shall be increased from 15% to 17%, and the scheduled tribes shall be increased from 3% to 7% respectively. This is under Article 16(4).
Yes.
Now, in the writ petitions, there is no whisper whatsoever as to why there should be any particular reference to any particular provision being invalid. Omnibus, there are general allegations, 50% rule is breached. My very respectful submission is the prayer itself is vague and it cannot be granted as it has been sought in the instant case because there are specific provisions. Why I say this is Justice Ragmohan Das Commission went into this aspect of the matter, whether the demand of the scheduled castes and scheduled tribes for enhancement needs to be considered and whether there is any justification and whether any specific case has been made out. The extraordinary situation to warrant the enhanced reservation in favor of scheduled castes to 17 and the enhanced reservation for scheduled tribes the Commission has collected overwhelming data, particularly to demonstrate 70 years of affirmative action in their favor at the rate of 15% and 3% has not done much to improve their lot. And they continue to languish socially and educationally backward. What are the features which the Commission has considered? May I request the court to kindly permit me to show from page 84 onwards. '74, National Law University also had conducted a study to which there is a reference. Page 74 onwards. The political representation has been considered. Political representation, by and large, it is proportionate to the population. There is no.
Yes.
Any page? Kindly come to page 138. The commission report starts at page 54, from 54, and kindly note the date. 27/2020 is the date of the report, and 22 is the date of the act.
Yes.
Yeah, literacy. Achievement in literacy rates. Page 138. Literacy is as important as that of wealth. This indicated the importance of education in the life of human being. One of the weapons available to achieve economic, social, and cultural progress for human beings is education. The SC/ST communities were deprived of education from time immemorial. However, the total literacy rate in the state was 25.40 in 1961. Total literacy rate was increased to 56.3%. The literacy rates of SC/ST went up to 38.04% and 36% respectively in 1991. In 2011, the total literacy rate was 75.36%, and the literacy rates of SC/ST were 65.32 and 62.10% respectively. That would show SC/STs still lag behind the general population in terms of the literacy achievement. They did not, universal education did not touch them as much as the general this thing. This was about the literacy. Then kindly come to para 84, page 84. I'm sorry, 96. Page 149. Page 149. The commission has conducted an in-depth survey to find out and employed Baba Sahib Research, B.R. Ambedkar Research Institute for purposes of studying the working conditions of the scheduled castes and scheduled tribes. Table 3.1 may kindly be seen. These are lists of scheduled castes which are presently found in the 101 castes list under 341. Over 51 of them are found to be still carrying on menial jobs, traditional occupations like footwear making, fish catching, leather industry, leather footwear making, or agriculture labor, traditional. As many as 51 castes are even now found to be occupying their traditional occupation, which is most low-grade employment, often considered as unclean employment. So this is another factor the commission has considered. All the 3 pages, it has listed the KAS. They number over 50, 51 to be precise. That is one of the factors considered. Then at page 154, under the scheduled tribes category, a corresponding study which reveals quite a good number of them are still hunters or agriculture laborers. Many of them are still bonded laborers. Those details are furnished in table 3.1. Next page, I request the court to kindly come to page 155. After the tabular statement, at the bottom of the table, at page 155, internal page 102, this is what the report says. According to the study conducted in 2019 by Tala Samudaya Study Center at the National Law School of India, University, Bengaluru, 74% of the tribal communities have remained invisible and marginalized. Kindly mark it. Even today, after 70 years, 74% of the tribal communities remain invisible and marginalized. The population of these communities has not exceeded 10,000. The literacy rate of these communities is lower than 30%. Of the 50 tribes, only 3 communities have a population exceeding 1 lakh, and the population of each remaining 47 communities is less than 1 lakh. Numerically, large communities are able to get all the benefits of the mainstream. However, other small communities have not been able to become part of it. Most of the marginalized and deprived communities still continue to be forest dwellers and they lead a nomadic life. So this is the status of the scheduled tribes.
No, how does this help in
Sorry?
In fact, this is what you're reading militates against your proposition that increase in the reservation would be helpful.
No, this is to show.
Increase the reservation, if these facts are correct,
Yes.
that they're invisible and they continue to not join the mainstream, then your reservation is obviously for the mainstream. It is not for, doesn't help them anyway. Unless you show that.
I brought on to that suggestion. This is to show the quantum of reservation is not enough to take the entire community forward and reach a level playing field. Because
that doesn't flow from what you're reading.
Later it comes. I'll be, no, I'm only reading the factors that have resulted in the backwardness of.
But one could have understood, larger part of them are vying for not that on a prima facie view, that a larger number of persons are vying for the same positions.
I agree.
And therefore you would. But here you say they're not. So irrespective of the mainstream benefits, they're not there. They're not vying for that.
No, with great respect.
What you have read, we are only
this way. No.
Anyway,
Later.
Let's go to the next.
Yes.
Followed what you said.
Yes. Now, after all this, kindly come to page 103. How these communities are still primitive is shown in the next chapter. And most obnoxious thing about the communities comes at page 159. Any civilized society should be ashamed of this situation. which prevails even today, 70 years after the Constitution came into force. Kindly come to page 160.
Yeah.
Sir, the scheduled castes are subjected to a practice in the name of religion, in the name of God. And they are called as Devadasis. Who are they? Why are they called Devadasis? Kindly come to the page 160, Devadasis system.
Yes.
Devadasi is meant to be a woman who is offered to be permanent service of God or goddess. The ritual takes place on certain determined time and place. This ceremony is generally organized mostly at the time of fair of God or goddesses. The adolescent girl is married to the statue of God or goddess by means of adoring the girl with a muttu, that is the pearl. This ceremony is called offering of Devadasi. In actual practice, in the name of offering girls to God or goddesses, they are forced to the service of rich trader or a landlord. This is done at the instance of the request or command of the rich people. Generally, these women are used by rich moneyed people belonging to high castes. This has been developed into a big business for human trafficking and flesh trade. So this is one of the factors with which the scheduled caste people are suffering as a religious practice. Then, and most important, kindly come to page 162. This is Safai Karmacharis. In Karnataka, they are known as Paura Karmikas.
Yes.
Those who are performing the acts of cleaning the individual toilets, public toilets, collecting night soil by hands and transporting it to faraway places, both in rural and urban areas, are called Safai Karmacharis. Kindly come to the last sentence in that. The number of SC/ST account for 99% of the Safai Karmacharis. In other words, it is only the scheduled castes and scheduled tribes who are condemned to this menial job.
Yes.
99% of them. The number of persons who carry night soil on head according to the 2011 census is 1,80,657. They clean almost 96 lakh toilets in the country. It is estimated that each year more than 300 people lost their lives performing this act. This act of carrying night soil is not only a social stigma, but also it affects the physical and mental health of this thing. Kindly come to the next page. I will not trouble the court with the other details. At the bottom of the page, at page 163,
Yes.
last 6 lines, my kindly.
Yes.
This is a study conducted by the Karnataka Commission of Safai Karmacharis. What does it show? The research report has shown that of the total Safai Karmacharis, 86.3% belong to Madhika community, which is a community which was condemned as a 80% belong to Madhika community. ST accounts for 3.9%. Remaining 10% belongs to other communities. The analysis of the data in the report reveals 95.8% of the Safai Karmacharis come under extremely low income. The population of Safai Karmacharis who do not possess any assets is 96.3%. So the Safai Karmacharis' educational backwardness is placed in the next page. Page 113, sorry, page 164. Educational and economic conditions of Safai Karmacharis. The proportion of literates among Safai Karmacharis is 50.10, and hence the illiteracy rate is 44.90. Those who have reported to the study team reveals 70.4% children enroll in schools, thus 29.6% of the children are not attending the schools. Of the total school-going children, 15% of them are receiving governmental facilities. Of the total number of children, 52.8% of them suffer from malnutrition. These are the findings recorded by the research group. Then, slum dwellers. The commission has taken a survey of the slums in Karnataka. Kindly come to page 166, table number 3.3. It gives the details of slums in Karnataka. Slum population details are given. I'll not trouble the court. Kindly come to the last but 3 lines. The number and the percentage of scheduled castes in slum population would be 34.25%.
Yes.
34.25% of the slum dwellers are scheduled castes. The percentage of scheduled tribes in slums is 14.52%. In other words, nearly 50% of the slum population comes from this community. Then the commission takes into consideration the atrocities committed against the scheduled castes and scheduled tribes. Sir, one factor I would request the court to kindly take judicial note of is untouchability was abolished by Article 17 on 26 January 1950. But even to this day, atrocities are committed against the scheduled castes because they were untouchables at one point of time. And this is evidenced at page 183 by the number of atrocity cases registered during the last 5 years. At page 183, table 4.1 gives the atrocities.
Every day, 117 cases into 5 lakhs.
One statement just above the table may kindly be perused. According to the data provided by the National Crime Record Bureau, 2018, the number of atrocities against scheduled castes and scheduled tribes recorded per day is 117. Every day, 2 murders are taking place. Every day, 8 rape incidents are happening. Apart from this, 3 serious injury incidents have taken place per day. The details are presented in 4.1. This is the situation in Karnataka, that the scheduled castes are even today subjected to the atrocities, scheduled castes and scheduled tribes. Kinds of atrocities and the details are given in the next suits, transfer of tribal lands, non-tribal labor system, the problem of indebtedness, not honoring the minimum wage act. The commission constituted to empower SC/ST Act has also highlighted many limitations and lacuna in the administration of SC/ST Prevention of Atrocities Act. The next page, kindly come to the last paragraph. At page 186, last paragraph.
Yes.
The scheduled caste and scheduled tribe, being poor, have been experiencing economic inequality, and being low caste, they are facing social inequality. Those who are economically, educationally, and economically weak become target of exploitation and suppression. They have to lead a life of slavery and destitution. Most of the victims of atrocity incidents are illiterates, poor, and women. Therefore, there is a relationship between violence on the one hand and on the other, illiteracy, poverty, and gender discrimination. Therefore, more attention is necessary for the educational, economic, and political empowerment of these communities. It is possible through the implementation of reservation, continuation of reservation, and increasing the proportion of their population from time to time in the state to reduce the atrocities of scheduled castes and scheduled tribes. This is one of the findings, very major findings. I request the court to kindly take serious note of. That if you increase the percentage of reservation, it is going to mitigate the suffering of these people. And the vulnerability of these sections is graphically brought out in the next chapter at page 189. Kindly refer to. Sir, most of these opportunities are taken away by the high caste people, upper caste people, forward caste people by producing false caste certificates. Those details are given how the cases are increasing from year to year. That is at page 189, table number 4.3. Then how they suffer from superstitious practices, which is one of their banes, is also brought out in page 191 onwards. I will not trouble the court. It is not my case that the upper caste suffer less because of superstition. But these people continue to suffer because of superstition is a fact which has taken note. Then the commission has taken note of the serious shrinking of the space for social justice and reservation. Two 117. About what? Page 217.
Yes.
How the space for reservation is shrinking, as a result of which seriously jeopardizing the prospects of the scheduled caste and scheduled tribe getting
Continue tomorrow. How much further will you take? You said 20 minutes, 2 hours.
Another 15 minutes I should be able to.
If you, as far as reports are concerned, if you want to read them, just give us the page number or the.
I go down to that. In fact,
Supply
I have already made, because the impact, yes, I'll give the. Tomorrow I'll conclude.
Tomorrow.
Please.